Absolutely. Just let me know when you're ready.
The method is more effective than the amplifier he was wearing. So
Sure.
Just kind of test to make sure he's able to hear accurately. Just say some stuff on the record. Just to make sure he can hear.
All right, testing, 1, 2, 3.
Good? Good. All right, thank you very much, Your Honor. I appreciate you.
Yeah,
Mr.
and
Sievers,
also-
if you can't hear at any point in time, you'll need to let your lawyer know so that we can address the issue. Yes, sir. Sure.
Mr. Sievers, can you hear from up here? Can you hear? I don't think that mic is on.
Tap it.
Yeah, it's on. Can you hear?
Oh, I did now, yes, ma'am.
I'll just ask him to speak.
Thank you very much.
State's ready.
Yes, Your Honor.
Defense is ready.
Yes, sir.
Next witness.
Next witness is Mr. Gregory Messore.
I told her 30 or
Tomorrow?
30 tomorrow.
Okay.
So I don't know what she picked, but
It doesn't matter.
either one.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you.
Good morning, Mr. Messore. Could you please state your name for the record?
Good morning. Gregory Jeremiah Messore.
And how are you currently employed at the moment?
I'm self-employed.
All right. Do you run your own law firm?
Yes.
How many years have you been an attorney in Florida?
1998.
And do you hold any other bar licenses?
Currently, no.
Okay. Did you used to hold any other bar licenses?
Yes, Massachusetts and federal court.
And prior to having your own law firm, where were you first employed, and if you could sort of walk us through your experience?
In Florida,
Yes, sir.
first I worked for Prudential Insurance in 1997 to 1998. When I moved from up north, then I got involved with the Public Defender's Office in Jacksonville. That's the 4th Judicial Circuit. And that was from 98 until about 2005. Went out into my own practice in Jacksonville until about 2009, and then returned to the Public Defender's Office until 2014 or 15, and then moved to Fort Myers.
And while you were at the Public Defender's Office, what types of crimes did you handle?
All of them.
Okay. How many felony trials did you have while you were at the Public Defender's Office, if you can recall?
Over 100.
And did you handle capital cases while you were at the Public Defender's Office?
Yes.
How many?
While at the Public Defender's Office, probably 5, and then 1 in private practice.
So that would be about 6 total
Correct.
through to verdict?
Correct.
And in those capital cases, what roles did you have in those cases? Did you handle guilt phase or penalty phase?
Both.
And what were the results of your prior capital trials?
Well, all 6 were first-degree murder cases, of course. All 6 resulted in guilty verdicts at guilt phase. All went to the penalty phase. And 3 of those were life recommendations, and 3 were death recommendations, but 1 was overturned by the Florida Supreme Court.
And how long have you been death qualified?
Approximately 2005.
So at this point, almost 20 years.
Yes. But I haven't been to the recent conferences that you need to go to maintain it, so I wouldn't say currently I am.
Okay. But at the time of Mr. Sievers' trial, you were death qualified?
Yes.
And you had attended the required continuing learning education seminars that are required to maintain the death qualification?
Yes, either death is different or the other one, which escapes me right now.
Would that be life over death?
Correct.
Now, in your handling of death penalty cases, were the roles of the attorneys always bifurcated? And what I mean by that is one person handle guilt phase versus penalty phase?
To my recollection, yes.
And in your death cases, did you primarily handle penalty phase or guilt phase?
Both.
Do you have a preference on guilt versus penalty phase?
In capital cases,
Yes, sir.
guilt.
Now, how did you become involved in Mr. Sievers' case?
After I had moved to Fort Myers, 2015, I believe, this case garnered a lot of media attention, and I was following it. And when I saw that the current defense lawyers on his case were having issues as far as their representation of Mr. Sievers, I contacted them and asked them if they might want to have a meeting and talk about my assisting them,
Okay.
which happened.
And do you recall roughly what year that was?
My best guess is 2017.
Thank you. And when you reached out to assist, who did you speak with?
Mr. Mike Mummert and his then partner, Tony Vega.
Okay. And did you meet with them in their office?
Yes.
Okay. And why was Mr. Mummert looking for a death qualified attorney?
I wouldn't say he was looking. I had reached out to them.
Okay. Were any of the lawyers involved in Mr. Sievers' case at that time death qualified?
No.
Now, at some point, did the court eventually file a court order allowing you onto this case?
Yes.
Were you paid for your work on this case?
No.
Now, what was your role supposed to be in this matter?
To assist Mr. Vega and Mr. Mummert in the case, and ultimately it would be penalty phase if it got to that point.
Okay. So your role was to be focused on the mitigation and the penalty phase presentation?
Yes.
Prior to this case, have you ever worked with Mr. Mummert?
No. Prior to this case,
Since this matter, have you
No.
worked with Mr. Mummert?
yes, we worked together on another murder case.
Okay. Did that case occur simultaneously with Mr. Sievers' case?
They were both going on at the same time.
Did that have an impact on your ability to work on Mr. Sievers' case?
I wouldn't say so, no.
And do you recall who was on the trial team for Mr. Mummert's office?
Well, Mr. Vega passed away during the pendency of this case, so Mr. Mummert was the only attorney. He had support staff.
Okay. Do you remember any of the names of the support staff?
Jen Mummert at the time, and No, I don't remember anyone else's name.
Now, as part of the trial team, were there frequent matters or frequent meetings or consultations with the trial team as to what to present for penalty phase or anything like that? Can you describe the dynamic?
Yeah, well, was your question frequent?
Yes.
And I'm not sure how to define that, but we had a number of meetings about the case, guilt and penalty.
Okay. And would you meet with Mr. Mummert in his office?
Initially, he and Mr. Fega had an office in Naples. I forget the road, main airport road. And then later on, Mr. Mummert had an office closer to downtown here. And I forget the name of the street. So we would meet there usually.
Okay. And were you provided the discovery in this case?
I would say a sizable portion of it. I know I didn't receive all of it.
Okay. And how did you receive the discovery in this matter?
Hard copies as well as electronically.
Okay. Now, did you and Mr. Mummert collaborate and coordinate depositions?
They did all the coordination of the depositions.
Okay. Did you attend the depositions?
Some.
Okay. Was Mr. Mummert lead on this case?
Yes.
Did he consult with you as to what he needed to do to prepare for this case, or pick your brain since you were the death qualified attorney?
I would say more pick my brain, but he handled almost all the majority of the preparation for it.
Okay. So he made the decisions as to who to depose,
Correct.
who to interview?
Correct.
Did he also make the decisions regarding what mitigation experts were used?
Yes.
Did you have any input as to which mitigation experts should be used?
No.
Not at all.
No, I was not familiar with the people down here who do this type of work as opposed to up north in Jacksonville. So I didn't have really any inkling of who you even go to down here for that kind of thing.
Okay. And is that because you were very recently moved to the area?
Yes.
Did you meet with the mitigation experts that were hired in this case?
Yes.
Do you recall who those mitigation experts were?
No.
Do you recall how many mitigation experts were involved in this case?
2, I believe.
Okay. Would the name Donna Murray ring a bell?
Yes.
Okay. Did you interact with her at all?
Yes.
Okay. Did you meet with Ms. Murray?
I don't recall. Face to face.
Okay.
It seems to me yes, but I don't recall.
Do you recall the name of the other mitigation investigator involved in the case?
No.
Would the name Jeffrey Giordano ring a bell?
We discussed it in my deposition. I believe so, but no, I don't remember specifically.
Okay. Do you recall interacting with that last mitigation investigator and asking him to do things for the mitigation investigation?
That was coordinated mainly through Mr. Mummert's office. The meetings were more as far as getting the witnesses aligned and who would be called and what they would testify to and what exhibits we might use.
Okay. Do you recall if those meetings were closer in time to trial?
Yes.
In the lead up to trial, did you have the opportunity to speak with any of the mitigation witnesses or interview them?
Yes.
And do you recall who you may have spoken to?
I'm not going to be good at any of the names because I'm just not good at names, but family members, brother, mother, stepmother, probably another brother, and I can't recall.
Did you meet with them in person or did you speak with them by phone?
In person.
Okay.
One of them maybe by phone because they were traveling, I think, from Missouri. But that person might have already been here in the days leading up to the penalty phase. So I'd like to say everyone was face to face. One could have been by phone.
Was that closer in time to trial or in the months leading up to trial?
Closer in time, I would say.
And did you have more than one meeting with these witnesses?
It's not all of them collectively, but some of them individually.
Okay. Now, in preparation for the trial, did Mr. Mummert consult with you regarding jury selection?
We discussed it, so if that's consultation, yes. But he was in charge, as lead chair of the guilt phase, he was in charge of the jury selection.
Okay. Did you give him suggestions as to what sort of questions to ask?
I don't think I gave him a list or anything, but we had several discussions where we talked about the process.
Okay. Now, as part of the continuing learning education seminars that are given for death penalty attorneys, do those seminars go over jury selection?
Yes.
Do they give materials for jury selection?
Yes.
Okay. Do you know if Mr. Mummert had access to those?
My recollection is that he did, and that he, I think, relied on them not relied on them 100%, but certainly utilized them in putting together his jury selection.
And now, when you say you discussed jury selection with Mr. Mummert, did that include discussions regarding change of venue?
As I believe I testified earlier, I don't have specific recollections about change of venue, except my only recollection is that it seemed to me that he was collecting media reports, articles and such. This is my recollection on this, but I've done a lot of murder cases, but my recollection is he was collecting some of those items for potential use in it, but I don't recall where that went.
So you do not recall what the decision may have been regarding a change of venue motion?
I don't remember.
Okay. Would it be fair to say that you did not draft any of the motions that were filed in this case?
Drafted, I would say no, but I know I would have had input on some of them and probably reviewed them before they were filed, but drafted them, I would say no.
Now, obviously, you met with Mr. Sievers during the course of your representation in this case.
Yes.
How often did you meet with him?
I don't recall. Obviously, they all would have had to been at the jail, unless we, spoke in court or, in a private room or something. But, gee, I don't know. 6?
6 times?
Perhaps.
And do you recall discussing what was needed for the penalty phase with Mr. Sievers?
What was needed? I'm not sure I understand that question.
Did you talk to him about the penalty phase and explain it to him?
Yes.
Okay. Did you ask him to provide input regarding the mitigation case?
Once again, I'm not certain what you mean by that, but the process was discussed, and everything that happens during that phase, if it gets there, was discussed. I know we spoke about his daughters at one point, and we decided we weren't going to call them as witnesses.
Now, regarding the penalty phase, did you and Mummert have a theme for the penalty phase?
Once again, I'm not sure about the question as far as a theme, but we certainly had a direction we planned to go.
And what direction did you want to go with the penalty phase?
That would be mostly highlighting Mr. Sievers' positive qualities and traits, of which there were many. Probably number one being his exceptional role as a father.
And was that a decision you and Mr. Mummert came to?
Yes.
And did you have the opportunity leading up to trial to review documents and information gathered for mitigation by the various investigators that Mr. Mummert had?
Yes.
Did you ever make suggestions to the investigators as to what information or further information you needed for the penalty phase?
I don't remember not having anything that I was interested in using.
During the mitigation investigation, did you happen to travel to Missouri or have an investigator do so?
I did not travel to Missouri. I think Mr. Mummert did conduct depositions at some point, but I didn't go to Missouri, and I don't know who else went to Missouri.
Did you try to have the Mr. Mummert's investigators obtain information regarding any prior head injuries or any school records or anything of that nature for Mr. Sievers?
Head injuries, I don't recall anything on that. School records, I specifically don't recall either. Yeah, I'm sorry, I don't recall.
Do you recall if there were any experts consulted for the penalty phase in Mr. Sievers' case?
There was a mental health expert consultant.
Okay. Did you speak with that mental health expert?
I can't recall.
Ultimately, was that expert used in penalty phase?
No.
Did you recommend any doctors or anything to Mr. Mummert for the penalty phase that you knew of from your prior experience?
No.
And did Mr. Mummert make all of the selections of any experts that were used in the case in both phases?
Yes.
Was there ever a presentation created for penalty phase to describe Mr. Sievers' childhood and family life?
A presentation?
A presentation or a PowerPoint?
My recollection is there was.
Okay. Do you know who created that?
I think that was a collaborative effort amongst his support staff. And then we would review it and move things around and adjust things.
Was that presentation used at trial?
That's my recollection, is it was.
Do you have a clear recollection of that, or would the record reflect whether that occurred?
The record would reflect. I've used them in several other death penalty cases, and unfortunately, after 7 of them, they kind of merged together.
And you don't have a clear recollection as to who may have contributed to that PowerPoint presentation or had input on it?
Well, I know that someone in his office, and I can't remember if it was his wife at the time or someone else. I think they had somebody who was very strong with computers, a younger person who was knowledgeable about that stuff, which I am not.
Now, previously you testified that there was more than one mitigation investigator involved in this case. Do you know why there was a switch in mitigation investigators?
Specifically, I don't recall. I do know that there was a breakdown in the communication or in the relationship that led to the replacement of the woman.
Would that have been Miss Donna Murray?
I believe that name sounds familiar.
Had you ever worked with Donna Murray prior to this case?
No.
And you don't know why the communication broke down?
I don't remember, no.
Were there ever discussions between yourself and Mr. Mummert about filing a motion to continue in this case?
This case was, I don't know how many times it was formally continued, but obviously the case took a long time to reach trial. So I can't comment on the number of continuances or who moved for what when.
If I may have a moment, Your Honor.
Yes, ma'am.
Now, all the records in Mr. Sievers' case, discovery, mitigation items, were all of those located at Mr. Mummert's office?
Yes.
Would you have to go over to Mr. Mummert's office to view these items, or would they email them to you?
Both.
Both? Did you spend a lot of time at Mr. Mummert's office reviewing all the documents?
No, I think I had access on my own to everything that I wanted to review or needed to review. I prefer things in hard copy because I'm old-fashioned that way. But if things had to be viewed on computer, I'd do it that way too.
In your prior cases where you conducted penalty phase, were those when you were with the Public Defender's Office?
I believe 5 out of 6 were.
Okay. So with the Public Defender's Office, there's a lot of support investigative staff, is that correct?
Yes.
Okay. Did you feel you had the necessary support and staff for this penalty phase?
Given the way that this penalty phase was going to play out, yes.
I'll pass the witness at this point.
Steve?
So, Mr. Messore, you had access to all the discovery in this case, right?
Like I said, I didn't review every single shred of discovery. Certainly all the things with cell phones and that stuff. I didn't spend much time on that, but I had access to it, yeah.
There was a lot of stuff, wasn't there?
Yes.
Tens of thousands of pages of discovery, right?
I would doubt that.
And gigabytes of data on hard drives and disks, maybe even terabytes, right?
Whatever those are,
Whatever
yeah.
that is.
Yeah, probably.
And you were able to see everything you needed to see in order to prepare mitigation, right?
I felt so.
And let's talk a little bit more about your history. You have a Juris Doctor degree, right?
Yes.
From which university?
University of New Hampshire?
And you also have an LLM, right?
Yes.
And where's that from?
University of San Diego?
And what is the LLM in?
Concentration in criminal law?
So you and I both have JDs. Mine's from University of Florida. What's the difference between a JD and an LLM?
JD is the 3-year regular law school curriculum, and the LLM is a 1-year graduate program after law school.
So an LLM is something that goes above and beyond what you learn in law school and get your JD.
It's a master's degree, yes.
Mr. Mummert also had the services of Al Olson and Marie Olson, their private investigative firm, at his disposal, right?
I had forgotten their names also, but yes.
And
Al. I remember Al.
you remember Al?
Yeah.
And Mr. Mummert also had the services of Jennifer Wood or Jennifer Mummert as part of the team as well, right?
Yes.
She was very active in the defense team, right?
Yes.
And it's safe to say that based on your experience and the training, you got a very good idea of what's needed in order to properly present a mitigation case, correct?
Yes.
And did you have everything, in fact, you had everything you needed in order to present your mitigation in this case, correct?
I felt so.
And despite the fact that a change of venue was never, a motion for a change of venue was never filed and venue was never in fact changed, Mr. Mummert did the research on the change of venue, right?
That's my recollection.
And as an attorney, have you often, in fact, as a trial lawyer, you've often researched different avenues, different defenses for your client, right?
Yes.
And then you make a tactical decision of whether or not to use that defense or that information, or a tactical decision not to use it, right?
Yes.
And this was a tactical decision not to change venue at this time, right?
Once again, I'm going to leave that to whatever the record reflects. I don't recall what surrounded that.
Okay.
Typically, I've never moved for a change of venue personally, but I know that during my course of time, the U.S. Supreme Court and then other courts found that usually you have to try to pick a jury. In the old days, you could move for change of venue and show a bunch of news articles, and the judge would say, okay, we're moving it. But I believe now you have to at least attempt to pick a jury first, and then if problems arise, then you look at venue change.
Okay. And we were able to pick a jury here in Lee County during State versus Sievers, right?
We did pick a jury, yes.
And you were involved in jury selection, isn't that correct?
Yes.
You were present at the defense table with Mr. Mummert and Mr. Sievers.
Yes.
You were able to give insight and advice on jurors that were being selected or talked about during your process, right?
Yes, we went over all the potential jurors before they were selected.
And Mr. Sievers and Mr. Mummert were able to listen to you and talk to you during that process, right?
Yes.
And in fact, Mr. Sievers was involved in the jury selection process as well, wasn't he?
Well, he was certainly here every day for it, yes.
And if he didn't like a juror or didn't think a juror should be on his jury, he was able to tell you and Mr. Mummert that, correct?
We all kept notes on the various jurors.
In fact, Mr. Sievers took copious notes during the process, didn't he?
He took a good amount of notes, yes.
And despite the fact that you volunteered to be on the Sievers team, Mr. Sievers didn't in fact hire you, right?
No.
He hired Mr. Mummert.
Yes. And Mr. Fega.
And Mr. Mummert and Mr. Mummert, at least after Mr. Fega passed away, Mr. Mummert was lead counsel, right?
Correct.
And Mr. Sievers was okay with that.
He seemed to be, yes.
You were okay with that.
Yes.
You also, along with Mr. Mummert, made tactical decisions on what to present and what not to present during mitigation, right?
Yes.
Such as the daughters.
Yes.
Now, unlike some of the other clients you've represented in death penalty proceedings, there were some things about Mr. Sievers that were different, right?
Yes.
He's got a high school degree, right?
I thought he had a college degree, too.
Got a college degree, correct, right? Mm-hmm. Didn't suffer from any known maladies such as substance abuse, alcohol abuse, right?
Not that I knew of.
Had no obvious mental deficiencies or physical deficiencies, right?
No, he's a very bright man.
So how did Mr. Sievers, those things about Mr. Sievers affect the choices that you made in mitigation?
He did not present as a damaged, broken human being, but as a generally upstanding member of the community. And so that was the way we presented it.
So your mitigation case for Mr. Sievers was to present him as an upstanding father, an upstanding member of the Lee County community, correct?
Basically.
And in other mitigations, you have clients who you present as broken individuals, right?
Yes.
They're mentally ill, they have substance abuse problems, they come from broken homes, things like that, right?
Yes.
Mr. Sievers' situation was different, isn't that correct?
Well, his parents had been divorced, but he certainly had loving parents and a support system.
And you were able to execute your mitigation plan to your liking, isn't that correct?
Yeah, probably except for the daughters. Of course, hindsight's 20/20, but given the outcome, maybe one or two of the daughters should have taken the stand. But I don't think Mr. Sievers wanted them to, and it was a lot to put. They were very young at the time. It was a lot to put two young kids through, and that decision was made.
And in fact, during the sentencing process, didn't a letter from one of the daughters kind of pop up during the PSI process?
Is that, I don't recall when it popped up, but, and I couldn't recall if it was a postcard or a letter. But yeah, yes, something did arise and it was entered, I believe, into evidence.
So even though you made a tactical decision not to call the daughters into court, that letter from one of the daughters still was able to be entered into evidence and made available to the court during the sentencing process, right?
Yes, and whether that was the penalty phase or the Spencer hearing, I don't recall.
So, during the process of defending a client, isn't it the lead attorney who bears the responsibility for ultimately making tactical decisions in the case, whether they're made or not made?
Yes.
Do the mitigation experts, especially the ones that aren't members of the bar, have responsibility for making tactical decisions?
No.
Do the mitigation experts have the ability to legally tell the, I guess, let me ask a better question. Does a mitigation expert's judgment over how to defend a client supplant the judgment of a member of the bar?
No.
And you said earlier that this case took a long time to go to trial. Was there enough time to prepare a defense in this case?
I would say yes. We went to trial, I believe it was next month. I think it'll be 6 years, November, I think it was. And the whole thing started in 2015. Mr. Sievers, I believe, was arrested in early 2016. There were a lot of discovery issues as far as getting things delivered to the defense. And I know that some computers were hard to read or something. And it was a big mess with all that. But ultimately, 3.5 years or whatever later, it appeared to be ready for trial.
And even though Mr. Mummert was lead counsel, if you as co-counsel felt that this case was not ready for trial, if you needed more time, would you have availed yourself of your ethical obligation to come in here and tell the court that you needed more time?
Yes.
And you didn't need to do that, right?
No.
Okay. I apologize, Your Honor. I had a brief conference with co-counsel. And despite the fact that or in addition to the fact that the letter from the daughter came in, you were also able to secure mitigation testimony from Sievers' family members about his role in his daughter's lives, right?
Yes.
The jury was able to understand his role as their caretaker, right?
Yes.
While Dr. Sievers was the breadwinner.
The primary breadwinner, yeah.
Primary breadwinner. And you also were able to produce testimony of not only the fact that he was their caretaker, but he was their loving caretaker, right?
Yes.
And in fact, you were able to secure testimony that his daughters wanted to maintain a relationship with him, despite the allegations against him, right?
Yes.
I'll just ask this question. I asked it in your deposition. I think it's fair to ask it now. trial lawyer to trial lawyer. Is there anything you would have done differently?
In retrospect, except for the daughters, I can't think of anything.
All right, thank you.
Defense.
Just briefly, Your Honor. Now, Mr. Messore, even though you primarily worked on penalty phase, you also reviewed much of the guilt phase evidence, is that correct?
I would say a lot of it.
Okay. And you also reviewed Mr. Jimmy Rogers' case?
Reviewed it. I monitored it.
Okay. You monitored it. You were aware of the state's presentation in that matter?
Like I said, I monitored it. I wasn't glued to it.
Would you say that case had a lot of similarities to Mr. Sievers' case?
I thought it did, yes.
Okay. And that it was important to monitor for the investigation of both of the guilt phase as well, correct?
I'm sorry?
It was important to monitor for preparation for the guilt phase, correct?
Oh, it definitely would have been, yeah.
Due to the similarities.
Correct.
No further questions, Your Honor.
State.
Nothing further.
This witness to be released or retained.
Release, Your Honor.
Agree? State?
Agreed, Your Honor.
Thank you. You're free to go.
Thank you, Judge. Good luck, Mark.
Defense.
Your Honor, that is our last witness we have for the morning. Our next witness we should be here this afternoon.
What time? 1:30?
I believe we told them 12:30. 12:30.
When do you guys want to come back? 12:30 or 1?
I'm looking at Madam Clerk.
Oh,
So I'm wondering when she
we don't
wants to
have-
come back.
We don't have anything else this afternoon. You guys are it, so it doesn't matter.
Judge, I think 1 o'clock is a good time. Give
1 o'clock?
everybody a chance to get a bite and come back.
Yeah, the only thing I have this week other than this is this morning I was assigned 2 cases that needed pretrial detention hearing, which will be tomorrow at 8:30. But they shouldn't take long.
That's fine, Your Honor. And in full candor to the court, we did have a few witnesses this morning that had some travel issues, so we had planned for them to testify this afternoon, but they will be here tomorrow. So we have the one witness this afternoon, and that's all we have for today.
You only have 1 for today?
Yeah.
We'll still be on track to wrap it up this week, though, correct?
Yes.
Absolutely.
Honestly,
Okay.
depending on how long your pretrial detention takes and the flow of the witnesses, I don't want to speak too broadly, but I think we can finish by Wednesday.
Okay.
At least
Just want to
for
make sure we're on
defense phase.
track.
Yeah, we are on track, absolutely.
Who's your next witness?
Our next witness is Donna Murray.
Okay. All right. Well, we'll see everybody at 1 o'clock.
Thank you, Your Honor.
Yes, ma'am. Maybe we should start with them at 9 o'clock.
Yeah. I think that makes sense.